Good day everyone, my name is Josh Febrer from BSA 1B. Today we're going to talk about the Chapter 8 and 9 of the Civil Code of the Philippines, Title 2, Contracts. Let's begin with Article 1403. Unenforceable contracts are contracts that cannot be enforced in court by reasons of defects until and unless they are ratified according to the law. Unenforceable contracts are more effective than voidable contracts because voidable contracts can be enforceable unless they are annulled. Unenforceable contracts, although valid, are unenforceable in court unless they are cured or ratified. So, there are three kinds of unenforceable contracts. Number one is unauthorized contracts. Number two is contracts that fail to comply with the statute of frauds. And number three is the contracts that the both parties are incapable of giving consent. The Article 1403 enumerates the contracts which are unenforceable. So, for the first paragraph, it simply says that these are unauthorized contracts. They are unenforceable. They need to be ratified by the principal before it takes legal effect. So, for example, you sell a property of the other in their name without having authority to sell that property or to dispose that property. So, for example, A sold the car of B in the name of B to C. So, the contract is really an unauthorized contract, and hence there's no legal effect unless B ratified that contract. So, how to be ratified? Either it is expressly or impliedly. Express if it is to be orally or written, and then implied if it is true by conduct. So, take note also if it is unauthorized contracts, not only that no authority has been given at all. It is also possible that you were given an authority but you acted beyond that power. So, for an example, A authorized B to mortgage his property but B actually sold it to another person. So, B acted beyond the power that A gave him. So, that's also an example of unauthorized contracts. For the second paragraph of the Article 1403, it talks about the statute of frauds. So, these are the contracts that fail to comply with the statute of frauds. So, the statute of frauds requires contracts that it should be in writing. So, the purpose is, aside from the fact that to prevent fraud, but it is also to guard against mistakes. So, the statute of frauds is applicable only to executory contracts or the not yet performed contracts. It is not applicable if the contract is totally or partially executed already. So, what are the contracts required under the statute of frauds to be in writing? So, number one is the agreements to perform not within a year. Number two is special promises to answer for the death of another. Number three is settlements for marriage excluding mutual promises to marry. Number four is sales of goods at a price above a certain limit, for example, 500 pesos. Number five is the leases longer than 1 year. And number six is the representations about someone's credit. For the last kind of unenforceable contracts are contracts that both parties are incapable of giving consent to a contract. So, if one party only is incapable of giving consent, that is voidable. But, if both parties are incapacitated to give consent, then the contract is unenforceable. We are done for the Article 1403. Let's move on to the Article 1404. So, the Article 1404, unauthorized contracts are governed by the Article 1317. So, let's go back to the Article 1317. So, the Article 1317 simply says that unauthorized contracts entered into without the authority of the principal are considered as unenforceable contracts. So, just like what we have discussed before, in Article 1317, there's these requisites for a person to contract in the name of another. So, number one, he must be authorized, expressly or impliedly. Number two is he must have, by law, a right to represent the principal. Number three, the contract must be subsequently ratified, expressly or impliedly. And the number four, he must act within his power only. So that's what Article 1404 simply says, that unenforceable contracts are governed by that provision, Article 1317. Let's move on to Article 1405. So for the Article 1405, this provision simply says that the ratification of unenforceable contracts. So there are two ways of ratification of contracts infringing the statute of frauds. Number 1 is failure to object to the presentation of oral evidences. And the number 2 is the acceptance of benefits under the contracts. So, there you go. The next articles will be discussed by Miss Allison Banal.
Article 1406. When a contract is enforceable under the statute of fraud and a public document is necessary for its registration in the Registry of Deeds, parties may avail themselves of the right under Article 1357. Statute of fraud requires certain contracts which are listed to be in a certain form to be enforceable, or so you can enforce them or sue upon them in court. If not in writing, you cannot prove the existence of the contract. This provision pertains to those that do not comply with the statute of fraud. It is not allowed to use oral testimony to prove the existence of the contract that requires it to be in writing or some book or memo that evidences the existence of the contract. This is the second kind of unenforceable contracts. For example, in the sale of real property, a verbal agreement to sell the land is valid. However, it is unenforceable, meaning it produces no legal effect due to non-compliance with the statute of frauds. The exception to this rule is if the oral sale of real property has been ratified, meaning there is a partial or full performance which can prove the existence of the contract. For example, A orally sold to B a watch for 1,000 pesos. The parties agreed that A would deliver the watch the following day. B, however, gave a down payment of 200 pesos. The sale is enforceable because A had accepted the benefit under the contract. If that's the case, the party can now compel the other party to put the contract in a public document for the purpose of registration. This is supported by Article 1357. Again, the statute of fraud applies only to executory contracts or those contracts that are not yet performed. It is clearly a rule of evidence. Article 1407. In a contract where both parties are incapable of giving consent, express or implied ratification by the parent or guardian, as the case may be, of one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. This is the third kind of unenforceable contract. It cannot be enforced since both parties will only use their incapacity as a defense against each other. For example, in a contract of a minor and an insane person, or a minor and another minor entering into a contract. Now, if the parent or guardian of one of the contracting parties ratifies the contract is no longer unenforceable. It will become voidable, meaning the contract is valid until annulled. If ratification is made by the parents or guardians, as the case may be, of both contracting parties, the contract shall be validated from the inception. If both parties ratifies, the contract is then validated, and the validity of the contract retroacts to the date when the contract was executed. Again, if one of the contracting parties ratifies the contract, it is voidable. If both parties ratifies, is valid. Article 1408. Unenforceable contracts cannot be assailed by third persons. Right to defense of unenforceability of the contract is available only to the contracting parties. The contract cannot be assailed by a stranger, or in other words, a stranger cannot question the unenforceability of the contract. Under a verbal contract, A sells a parcel of land to B. C binds himself in writing for the performance by B of his obligation to pay the purchase price. In an action by A to recover the purchase price, C cannot assail the contract between A and B for being unenforceable under the statute of frauds, because C is a stranger to the contract. Again, the benefit of statute of fraud may only be claimed or waived by the contracting parties. It is also important to take note that unenforceable contracts may only be assailed as a way of defense, not by direct action.
Good day everyone, I am Aira May and now we will proceed to Articles 1409 to Article 1411 of the Civil Code under Law on Obligations and Contract. These provisions talk about void and inexistent contracts that are treated as if they never existed. Let's begin with Article 1409. So let's first understand what a void contract is. A void contract is one that has no effect from the beginning. It's like nothing was ever agreed upon. The law does not recognize it. So these contracts cannot be ratified or fixed, even if both parties want to. And any action to challenge them does not prescribe, meaning you can question them anytime. Now, to understand the void contracts better, let's proceed to the examples or the 7 kinds of void contracts. First is those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. These are contracts that violate basic rules or values of society. For example, the contrary to law. Example, Anna agrees to serve Ben without pay until her debt is settled. This is against the labor laws. Even if Anna agreed, the law requires proper compensation for labor, so this contract is void. Contrary to morals. Anna is paid 50,000 to become Ben's live-in partner. This is immoral. Living together in exchange for money without marriage offends public morals, so this contract is void. Next is contrary to good customs. For example, Anna agrees to slap her father. Respect for parents is part of good Filipino custom. A contract that promotes disrespect is not allowed by law and is considered as void. Next is contrary to public order. For example, a lease allows a landlord to forcibly evict a tenant without legal process. Only courts can order eviction. A private contract allowing violence violates public order, hence this contract is void. Next is the contrary to public policy. For example, a buyer of land can only resell it to the original seller or their heirs and only at the original price. This permanently limits ownership rights. The law allows free disposal of private property, so this restriction is against public policy and is considered void. Now let's move on to another example of void contract. These are absolutely simulated or fictitious contract. This is when both parties pretend to enter a contract but they don't really intend to follow it. For example, Anna sells her land to her father-in-law to avoid paying debt, but she never gets paid and continues living on the land. They only pretended there was a sale since they never intended it to be real. It is a sham and therefore considered void. Another example of a void contract is those contracts whose cause or object did not exist at the time of the transaction. For a contract to be valid, it needs a real cause or reason and object, the thing being transacted. If there are missing, the contract is void. For example, Anna sells land to Ben for 100,000, but there was no intention of payment. If there is no actual payment or consideration, the cause is fake, so no real sale happened. The contract is considered void. Another example of a void contract is those contracts whose object is outside the commerce of men. This is when some things can't be owned or sold, they belong to the public. For example, a person tries to sell a sidewalk or a public plaza. These are public properties and cannot be sold or bought privately. Any contract that attempts this is considered also as void. Another example of a void contract is those contracts that contemplate an impossible service. This is a contract requiring something that can't be done and is considered void. For example, a blind man enters a contract to paint a mural. He cannot perform the task due to blindness. This is not a temporary obstacle but a permanent impossibility, making the contract void. Another example is contracts where the parties' intention can be determined. It is a contract where we can figure out what the parties meant. The contract is considered void. For example, Anna agrees to sell her land to Ben, but she owns 5 lands and doesn't say which one. If the land being sold can be identified, there's no valid object, so the contract considered as void. Lastly, a contract expressly prohibited or declared void by law. These are contracts where declared void by the civil code or other laws. For example, a person sells property they expect to inherit, but the inheritance hasn't happened yet. This is a contract over a future inheritance, which is prohibited unless specially allowed by law, so it is considered void. Now, let's proceed to Article 1410, still under the void or inexistent contract. The action or defense for the declaration of the inexistence of a contract does not prescribe. Now, let's break down this article line by line. The action in the article means filing a case in court, and the defense means raising the issue of nullity when someone sues you. And the does not prescribe means there is no deadline. So if a contract is void, you can file a case anytime to declare it void and raise it as a defense in court even after many years. For example, S was tricked into signing a deed of sale by B, but no money was paid, so the contract lacked cause. However, B said the case was filed too late. But under the Article 1410, still under void or inexistent contract, void contracts can be challenged anytime. Remember, this applies only to void contracts. If the contract is just voidable, for example, due to fraud or incapacity, the law gives you only 4 years to file an action. Now for Article 1411, still under the void or inexistent contract. Let's break down this article line by line. First sentence, when the nullity proceeds from the illegality of the cause or object of the contract and the act constitutes a criminal offense, both parties being in pari delicto, they shall have no action against each other and both shall be prosecuted. So, for explanation, if a contract is void because the cause or object is illegal and it's also a crime and both parties are equally guilty, in pari delicto this means in equal fault, then they can sue each other, the law won't help either party and both can be charged criminally. Now for the next line, moreover, the provisions of the Penal Code relative to the disposal of effect or instruments of a crime shall be applicable to the things or the price of the contract. This means that anything involved in the illegal contract, like money or goods exchange, can be confiscated by the state under criminal law. What if only one party is guilty? Then this rule shall be applicable when only one of the parties is guilty, but the innocent one may claim when he has given and shall not be bound to comply with his promise. This means that if only one person committed the crime or knew about the illegality, then the innocent party is protected. They can get back what they gave and they don't have to perform what they promised. For example, Anna and Ben enters into a fake sale to avoid paying taxes. Both know it is illegal, so they are in pari delicto. Then they can sue each other and the government can confiscate the land and prosecute them. But if Ben tricked Anna into signing the document and she didn't know it was illegal, then Anna, the innocent one, can recover what she gave and won't be punished. Now, to summarize everything from Article 1409 to Article 1411, void contracts have no effect at all. They can be ratified and can be challenged anytime. Under Article 1410, the action or defense for void contract does not prescribe, meaning it has no deadline. For Article 1411, it says if the void contract is also a crime, the law won't help guilty parties, but innocent parties may still recover. Thank you for listening. Now let's proceed to another articles.
Moving on to the next article, which is Article 1412. This article is somehow the same with Article 1411, but the difference is in the case of criminal offense. So according to Article 1412, if the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. It said that as long as there has been no committed as criminal offense, also unlawful or forbidden act that does not contain criminal offense, there are following rules to be observed. Number 1. When the fault is on the part of the both contracting parties, neither may recover what has been given by the virtue of contract or demand the performance of the other's undertaking. So, in this case, when both parties are at fault or pari delicto, neither of them cannot recover of what they have given during the contract, and also they cannot demand for the performance of the other as long as they didn't commit any criminal offense. Number 2. When the only one of the contracting parties is at fault, he cannot recover what he has given by the reason of the contract or ask for the fulfillment of what he has promised him. The other, who is not at fault, may demand for the return of what he have given without any obligation to comply his promise. In this case, when only one is guilty or in delicto, in the part of the party that is guilty, that party loses everything that he have given and cannot ask for the fulfillment of the other. And the other part that is innocent may demand for the return of what he have given and cannot compel to comply his promises. According to Article 1413, interest paid in an excess of interest allowed by the usury law may recover by their debtor with the interest thereon from the date of the payment. This article applies when someone is charged usurious interest, that is, interest rates are unreasonable high or illegal. If the debtor has paid interest beyond the legal limit, they have the right to recover the excess, not only the excess be recovered, but also the subject of the legal interest starting from the day it was paid. Example, if the legal interest is 12% per annum and the lender charged 36%, the borrower may recover the 24 excess payment plus the interest from the date of the payment. Note that while the usury law has been suspended under the Central Bank Circular Number 905, the Supreme Court has still ruled that the unreasonable rates can be reduced or disallowed. So this article is still relevant to ensure fairness. According to Article 1414, when money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished or before the damage has been caused to the third person. In such case, the courts may, if the public interest will thus be subserved, allow the party repudiating the contract to recover the money or the property. There is an exception to the rule of the pari delicto, wherein we all know that there should not be a recovery. But under this article, it provides a case wherein recovery can be made by the parties even though they are in pari delicto. However, there are requisites to recover. First is the purpose is not yet been accomplished, and the second, the damage has not been caused to the third person, meaning no one yet is harmed.
Now let's discuss about Article 1415, where one of the parties to an illegal contract is incapable of giving consent. The courts may, if the interest of justice so demands, allow recovery of money or property delivered by the incapacitated person. This article is an exemption to the in pari delicto rule under Articles 1411 to 1412. It allows recovery by an incapacitated party, such as minor or a person with a mental disability, who entered into a legal contract provided that justice and equity so demand. In pari delicto means in equal fault. For example, a mentally disabled adult enters into a loan contract with a moneylender who knows about the condition. This person gives 20,000 pesos as partial payment. The court may allow the return of the 20,000 pesos because the person was legally incapacitated. Article 1416. When the agreement is not illegal per se, but is merely prohibited, and the prohibition by the law is designed for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered. This article allows recovery in contracts that are not inherently illegal but are prohibited by the law to protect one party. If the prohibition exists for the benefit of that first party, such as in labor or consumer laws, they may recover what they have paid or delivered as long as public policy is thereby upheld. For example, an employee signs a contract agreeing to waive his right to government-mandated benefits like SSS or PhilHealth in exchange for a higher salary. Since this waiver is prohibited by the law for the employee's protection, he can recover the benefits lost. Article 1417. When the price of any article or commodity is determined by statute or by authority of law, any person paying any amount in excess of the maximum price allowed may recover such excess. This article protects consumers by allowing them to recover any amount paid beyond the maximum price set by law for goods or commodities. Even if the buyer was unaware of the price violation, they may still reclaim the excess. For example, during a state calamity, a pharmacy sells face masks at 100 pesos each, even though the DTI set the maximum price at 30 pesos. A customer who bought 10 masks may claim back 700 pesos since 70 pesos excess times 10 masks. Article 1418. When the law fixes or authorizes the fixing of the maximum number of hours of labor, and a contract is entered into whereby a laborer undertakes to work longer than the maximum task fixed, he may demand additional compensation for service rendered beyond his time limit. This article reinforces labor protection by entitling workers to additional compensation for services rendered beyond the legally prescribed maximum working hours. If a labor contract requires work beyond limits set by law, example, 8 hours per day, the worker is entitled to overtime pay. For example, a fast food crew member is regularly required to work 12-hour shifts without being paid overtime. Even if the employee agrees, the employer must pay additional compensation because it violates labor laws on working hours.
Article 1419. When the law sets or authorizes the setting of a minimum wage for laborers, and a contract is agreed upon which a laborer accepts the lower wage, he shall be entitled to recover the deficiency. Meaning, if an employee receives less than the minimum wage rate, he can still recover the deficiency with legal interest. For example, if the minimum wage is 500 pesos per hour and he only got 400 pesos, then the employee can legally claim the 100 pesos difference. Article 1420. In case of divisible contract, if the illegal terms can be separated from the legal ones, the latter may be enforced. Meaning, if the contract is indivisible and part of the consideration is illegal, the whole contract is void. If the different parts of the contract cannot be separated or treated independently, and any part of what is being exchanged, the consideration is illegal, then the entire contract is being void. Article 1421. The defense of illegality of contract is not available to third persons whose interests are not directly affected. Only those who are directly involved in the contract or whose right be directly impacted by its illegality can argue that the contract is void due to being against the law. Outsiders who have no direct stake in the contract cannot use its illegality as a way to interfere with it. Article 1422. A contract is the direct result of a previous illegal contract is also void and inexistent. Meaning, a contract which is the direct result of a previous illegal contract is also void and inexistent. In simple terms, if a new contract is created based on a prior contract that was illegal, the new contract is also considered void from the beginning. The illegality of the first contract contaminates the subsequent one. That's all for Chapter 8, Unenforceable Contract, from Article 14 to 1408, and Chapter 9, Void or Inexistent Contracts,
from Article 1409 to 1422. I hope you've learned a thing or two from us today about this article under law on obligation and contracts. Thank you for watching.